Number 47, Carlson versus AIG. Good afternoon, Counsel.
Good afternoon, Your Honors. May it please the Court. My name is Ed Marcarian. I'm the attorney for the plaintiff, and we would request 2 minutes for rebuttal, please.
Yes, sir.
Your Honors, the Appellate Division erred in this case in holding as a matter of law on a CPLR 3211 motion that the contractor vehicles could not be insured as hired autos under the defendant's insurance policies.
On that point, on the hired auto point, and I know, I'm not saying we will do this, but if we were to find these weren't hired vehicles used with permission, do we have to get to the other issue, the statutory issue, on issued or delivered?
Your Honor, that may be moot at that point. On the issued or, I thought you meant on the AAIC issued.
No, on the issued or delivered.
On the issued or delivered issue.
Because there would be no coverage at that point, right?
Your Honor, could you ask it again? I'm just not following.
If we were to disagree with you on the hired auto, agree with the Appellate Division, that these are not hired autos, would we need to get to the issued or delivered?
No, that is the AIC issue, Your Honor, the statutory issue, the 3420. No, you would not have to reach that. And that is a compelling issue of statewide importance. But if I don't prevail on the other issue, that issue is a hollow victory for me. And I understand that jurisdictionally that you might not be able to reach it because it would be moot. So
am I correct that the 3420 claim does not apply to AIG because they're not an insurer here?
That's correct. The National Union is the insurer that stays in the case even if the 3420 issue is successful for AIC, which it should not be, Your Honor. But National Union would still be in the case. So with respect to the hired auto question, Your Honors, there are 4 important points that the Court needs to consider. Number 1 is that federal law requires that these vehicles have $5 million of coverage.
But wouldn't that be a question for DHL if that happens at some point and they are underinsured? The feds can certainly, that would be some kind of penalty, but what we're looking at is a contract here.
That's right.
So what is the contract provide for in terms of what vehicles are insured? They may have a problem at some point with the feds if the catastrophe you have in your brief happens, but I don't see how that affects how we look at this.
I think it's supremely relevant, Your Honor, because this is a 3211 motion. They're asking you to review cold documents in a vacuum, and we submit.
Which is generally the case in an insurance contract, though, right? If the language is clear.
But, Your Honor, when you can see business motives from the documents they've submitted to you, and you can see that federal law requires this coverage, and to assume.
But that's extrinsic to the contract itself, is it not?
It's a business motive, Your Honor. You're being asked to conclude on 3211.
Well, the question is, why are you looking at the documents? If you first start out with the insurance policy itself, if that resolves the question, unless you're going to stand up and argue that the provisions are ambiguous, and if the court were to agree with you, it's a different argument. But if the court finds it's unambiguous, you don't look at the other documents. Isn't that correct?
Your Honor, it is ambiguous. I do think business motives are relevant to understanding the documents in front of you.
Did you argue that it was ambiguous in the courts below?
Yes, Your Honor. Yes.
I thought you argued that it was unambiguous in your favor.
Well, that's correct. That's going so far to the other extreme at the motion court. They said it was so unambiguous, but at a minimum that preserves that it's ambiguous, and they argued forcefully, Your Honor.
Let me ask you another question. Has this provision been in other insurance policies pretty pervasively, the hired auto provision?
Yes, Your Honor. This court in the...
And have we ever had trouble interpreting it, or have we ever said that it was ambiguous? And I mean,
Yes, Your Honor. You did in the Jefferson case. You found an ambiguity with respect to the notice issue, and then you looked to the cost of hire schedule to determine that the vehicle was covered.
So what makes it ambiguous here?
The biggest ambiguous factor, Your Honor, is that they didn't give you the whole insurance policy. You can't say that the policy is unambiguous when you don't have the whole policy. You don't have the most important schedule.
How do you get around the permission issue? because even if, let's say, we could assume that in some sense, these vehicles could be hired by DHL, you know, for use by MVP owns them, and somehow DHL is hiring them. DHL still has these provisions in their contract with MVP about use outside of business hours, and that's clearly what happened here. I mean, there's already been a finding of that. So how do you get around the permission restriction in the contract language?
Because the language in this policy on permission is exactly the same for hired and owned vehicles, and just like MVP in this case was
They're
found.
an owner. They're an owner, and we have a statute that talks about a presumption of permission when you're an owner.
That's
These are,
correct.
you're not saying that DHL is an owner.
I'm saying that they defined hired, permission as to hired, in their insurance policy, the exact same way they defined permission as to own.
Where's that?
It is at, it's right in the insurance, I'll read it.
If you could. that'd be
Yes.
helpful.
Who is an insured? Anyone else.
I'm
Well,
sorry, where are you reading the
This
policy?
is right from the policy.
Or what
Would-
page
would
in the
be
appendix? What do
record.
If you just say the provision, do you have the provision number there?
Yes. It's record pages 1815 to 1816.
Thank you.
Who is an insured? Anyone else while using with your permission a covered auto you own, hire, or borrow. So permission is in the same sentence of their policy as own and hire.
Right, but I think the problem I have with that argument is, and even the vehicle and traffic law, it's not defining permission. It's saying owner, you get a presumption of permission, which is, I think, why MVP had a problem even in the appellate division originally on appeal. But when you hire a vehicle, you're not the owner, so permission is something different. You're defining the term permission by owner and then saying it also applies to hired vehicle.
Only because this insurance policy permission refers to own and hire in the same sentence.
Right, and owner, you get a presumption, hired vehicle, you do not.
I don't think that permission in one sentence can have two different definitions.
But
Your
it
Honor.
doesn't. It has a different definition because the vehicle and traffic law, or whatever that statute is that says an owner is presumed to have given permission, which is what the appellate division used here.
I was-
Permission means the same thing. It's just, do you have a presumption of it or not?
Well, the statutory definition is constructive permission, and that has to have the same meaning when it's defined in the same sentence of the insurance policy.
But it's not defined. Permission isn't defined in that sentence.
It incorporates the statutory definition. It has to, Your Honor, to give the coverage that's required by the statute. And if they wanted to, they could have written differently, because they did draw that distinction in their policy between symbols 8 and symbols 9. Symbol 9 says that employee vehicles, if they're not used in the course of the employer's business, then they're not coverage. For hired vehicles, they don't have that limitation. And again, that shows that if they wanted to limit it, if they wanted to give that definition of permission a different definition, they did so in limiting language in the policy, and they did not do that with respect to hired autos. So it has to be the same definition of permission. Your Honors, the most crucial document here is the cost of hire schedule. We have overwhelming underwriting evidence showing that these vehicles...
Did you have discovery here?
We did have discovery, Your Honor, not complete. We know it's not complete. There has been ongoing discovery. We certainly have not found out where the cost of hire schedule is, and that's the most important schedule in the policy on the hired auto question. We need to have that document. If you look at the Manchester case, which we've cited, it goes through carefully showing how the hired auto coverage was found there based on the cost of hire schedule, which we don't have here, and this is 3211. They have not established conclusively with their documents that the coverage cannot be found.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Good afternoon, Chief Judge DiFiore, and may it please the Court. I'm Kevin Sapansky, here for National Union and the AIG defendants.
Why is the absence of that cost of hire provision not determinative of whether you conclusively established your position as on documentary evidence?
A couple of points, Judge Stein. First, and as a threshold matter, there was a question about, and Your Honor asked the question about discovery. The record on page 1315 reflects the fact that in between the first and the second stage of briefing and argument below in the Supreme Court, Mr. Carlson was afforded discovery. He did not serve document demands or interrogatories. Instead, he served a notice to admit and a single notice of deposition of the excess underwriter. So clearly had an opportunity to depose the primary policy underwriter, and for whatever reason chose not to do so. To respond more directly to your question, there is a threshold question, I think Judge Rivera touched on. It's the question of ambiguity. And here we're dealing with two fairly common terms. The question of hire means to obtain the use of someone's services or something for payment. Permission means authorization. These are common everyday terms, and that's probably why.
On that point, I was having a little trouble with this. Are there different definitions? Are there different areas of permission in terms of a vehicle owned by MVP or a hired vehicle? Are there different provisions in this contract governing what you can do with a vehicle if it's owned by MVP or if it's hired? I was having some trouble with that.
No, thank you, Judge Garcia. No, not at all. There's no distinction whatsoever. And the argument that my colleague was making earlier, that somehow the definition of permission changes because there needs to be some tie-in between Section 388 of the Vehicle and Traffic Law and the policy language, I think that's a valiant effort to try to create permission, but I don't think it works because, as Your Honor pointed out, Section 388 imposes liability on an owner for accidents involving vehicles used with express or implied permission. And here it's very clear and it's undisputed, in fact, that MVP is the owner.
Is it so clear here that hired is unambiguous, or is it ambiguous? What do you say?
I think it's crystal clear that it is unambiguous, and I agree with the plaintiff's first position on that issue below, that it is unambiguous. And I think with good reason. There really is nothing about the context of the term or the complexity of the definition that should render it unambiguous. And that being the case, Judge Abdus-Salam, I think the analysis of the underwriting evidence is a moot point. But to get back to your question, Judge Stein, there is an argument. The plaintiff has raised the argument about this schedule. I don't know that it's a missing schedule. It just appears to not exist.
Is it part of the contract?
The schedule is part of the declarations, which is part of the contract, Judge Carter, but happens to be empty, and so to attempt to fill it in from the underwriting information would effectively be the importation of extrinsic evidence.
The advice I got very early on was never call a judge by his or her name because you're liable to get it wrong sometimes.
Yes, duly noted. But, Your Honor, thank you for the question. It is a critical point. If the schedule is blank, then any attempt to complete it would resort to extrinsic evidence. Let me speak briefly about that schedule then. The schedule does not list, there's no room in the schedule for a description of particular makes and models of vehicles. It plainly would not tell us whether any particular vehicle, much less the MVP van, is a hired auto. It contains...
What's your basis for saying that? I mean, do you have the schedule?
There is, Your Honor, it is not in the policy itself, and it's not in the underwriting file. As best we know, there isn't one. There are schedules in the underwriting file that was produced to the plaintiff. My basis for saying that, though...
So you're resorting to extrinsic evidence to demonstrate what would be in the cost of hire schedule if it existed?
Not at all, Your Honor. I'm resorting to the line items of the schedule itself. The line items include...
You don't have the actual schedule from this policy?
We have a form for the schedule, Your Honor, and so we know it's item 4 in the declarations.
I guess the point is, how do you know the form matches the document if you say the document isn't in any file, so how do you know?
Well, that's a fair point, Judge Rivera. I think the answer to that is if the plaintiff's position is that this schedule, as reflected in item 4 of the declarations, should be somewhere in the underwriting file, then presumably it's a fair inference that that schedule would match the categories of information that are in the in item 4 itself. But you're correct. We have no similar schedule in the underwriting file. We have charts that contain information about the numbers of vehicles. And for purposes of underwriting, Judge Stein, it looks to be like what Mr. Flynn, who is the excess underwriter, was primarily concerned about was not any particular vehicle or make and model of vehicle, but the number of vehicles. How many vehicles did DHL own? How many vehicles were not
Does it
owned?
matter, does the number matter? What if the policy covered all DHL vehicles?
Well, the answer to your first question is no, Your Honor, it doesn't matter. And the answer to the second question is, as to DHL, it does cover every vehicle, whether DHL owns it or not. This policy broadly covers DHL for an accident involving any vehicle anywhere in the world. But the coverage is narrower for entities besides DHL. For those entities, the accident has to involve a vehicle that DHL hires and that is used with DHL's permission. And
On that point, counsel, let's say this schedule, if it was anywhere, it would list, or it would go to, as I understand it, the vehicles that would be covered, right? The hired vehicles. But you would still need permission, right? It wouldn't, the schedule is never going to answer the permission question, right? So if there's no permission, what's the difference as to what's on the schedule?
That's exactly right, Judge Garcia. If you assume for a moment, and it's a hefty assumption, let's assume for a moment that there were such a schedule and it listed all 7,000 non-owned vehicles of DHL in all the 43 states in which it does business, and the MVP van were on that schedule, then we would not have a very good argument on the hired auto side, but we would still have the issue of permission. And even if the vehicle is hired, the fact remains that there is no evidence in the record, and we do have a benefit of a trial record below. So it's a little bit different than on the typical CPLR 3211A motion. There is no evidence to suggest that DHL did anything or said anything that could be construed as permission. The witnesses, not only DHL, but the MVP witnesses in the underlying trial testified that DHL had no ability to authorize the use of a vehicle for business purposes, much less for a personal errand.
Is there any language in the contract with MVP about what MVP's vehicles could be used for that were worked, the DHL labeled vehicles could be used for outside of business? Was there a restriction in that contract between DHL and MVP?
There was not, Judge Garcia. There was not. The closest that you come to it is there is a provision that governs whether MVP may deliver packages for a DHL competitor, and the provision provides that it may, but it needs to have DHL's permission to do so. We don't know whether that situation ever came up, but there's nothing that limits MVP's use or operation of these vehicles. In fact, and we've cited to this in our brief, and we can. I would direct the court to pages 431 to 433 of the record. Essentially reflects sweeping control on the part of MVP of its own vehicles. It has the sole authority to decide what vehicles to furnish, how to operate those vehicles, how to staff those vehicles.
So what's your position? That DHL hires MVP to do the business, which is DHL's business, which I want to know if you think there's a difference, because they're basically doing your business. Your business is to deliver items, and that's what you hire them to do, as opposed to the manner by which they complete this agreement with you?
And I represent National Union, Your Honor, but I understand your
Yes, I'm
question.
sorry, with DHL,
No, I
yes, I'm
understand
sorry.
your question. Essentially, and this is consistent with the decisions of courts, both this court in Derry Lee and in other courts across the country, including the decision in Phillips, DHL has hired MVP to perform transportation services and then affords MVP sole control over the manner and means by
I understand, but
which
how are they going to accomplish that service without the trucks?
True enough,
What would
Judge.
you've got to be hiring, I'm sorry, DHL's got to be hiring them with the understanding that the only way they can accomplish the task for which they're hired is through these trucks. And they go through great detail in their agreement to say, this is what the trucks need to look like, I need the DHL label and logo on it, they have to wear these uniforms.
Certainly, Your Honor, and let me take that question in two parts. First, I'll take the last part first. Certainly, there are provisions in the agreement governing what the uniforms should look like, and Chief Judge...
You may.
Thank you. there are provisions that govern the manner in which MVP protects and uses DHL's intellectual property. And this is to the first part of your question, Judge Rivera, there is a difference between how MVP treats DHL's trademarks or intellectual property and whether DHL exercises control over the use of the vehicles themselves. And the color of the uniforms and the depiction of the intellectual property marks does not establish control. They're two different questions, and I think that, again, the plaintiff has tried valiantly to contort that into some means of controlling the vehicles, but it just doesn't work that way under the cartage agreement or the policy. And I thank you very much.
Counsel?
Thank you, Your Honor. Good afternoon, Your Honors, and may it please the Court. My name is Paul Kovner, and I represent American Alternative Insurance Company. And my argument today is limited to the issue which is unique to American Alternative, specifically whether plaintiff had the right to bring a direct action against my client. And our contention is that under the amendment to the statute, they could only bring a direct action as to policies which were issued or delivered in New York. And we think the Fourth Department was correct in its decision that the policy was neither issued nor...
Did AAIC know that DHL had a facility and a relationship with MVP in New York?
I don't know that it did or not, but
Is there any reference in the insurance policy to any risks in New York?
I don't believe there is, but I don't think it really mattered because the policy was not issued in New York, and therefore the statute wouldn't apply.
That's not an argument you made to the appellate division, correct?
Pardon?
That's not an argument you made to the appellate division.
Well, actually, I think there's been a lot of controversy about that, and the plaintiff contends that we did not make that argument, and even the appellate division in its decision says that we conflated the two standards, that is the prior standard, which was issued for delivery, with the standard in the amendment, which is issued or delivered. Frankly, Your Honors, I reread the briefs that we submitted in the appellate division, and I would say that we did specifically argue in that court that the standard was issued or delivered, which is the standard in the amendment. However, we spent a great deal of time in the brief arguing the prior standard because that was the standard which was argued extensively.
Was the amendment intended to give broader application of the statute or to narrow the application of the statute?
That's an interesting question, Your Honor, that I've been struggling with, and I would submit that you could say that the amendment was designed to broaden the protection because it added to the analysis the question of where the policy was issued. And that was not a factor which was present prior to the amendment. So you could have a...
Where do you get that sense of why the amendment was enacted, counsel?
That's
As
just...
opposed to is just trying to be consistent with other wording in the statute.
That's just my own gloss on the language because I've been struggling with the question of whether the amendment provides greater protection or less protection. But I think the legislature, in its infinite wisdom, chose the standard that is set forth in the amendment, and therefore, under that standard, as the Fourth Department held, plaintiff may not bring a direct action against my client. Though, if there are no further questions, thank you very much.
Thank you. Counsel?
Good afternoon. May it please the Court. My name is Patrick Lawless. I represent defendant DHL. The only claim in this action that's alleged against DHL is that DHL entered into a conspiracy with AIG to withhold the amount of available insurance coverage for obvious reasons. If you look at the allegations in the complaint, they're very broad, they're very speculative and conclusory. They don't rise to the level of asserting a claim. New York does not recognize a claim for civil conspiracy. The plaintiff has to allege an underlying tort. Assuming that it's fraud, they don't even set out the elements of a fraud claim for obvious reasons based on the decision from the Fourth Department in the first Carlson action that Mr. Porter was acting on his own and wasn't acting within the scope of his employment, and based on the Fourth Department's recent decision that there's no coverage to begin with.
Now that you're representing DHL, not the first gentleman who got up.
Yes, I'm the one who represents DHL.
Yes. So let me circle back to that question that I asked him, and I appreciate his answer. Given the relationship between DHL and MVP, right, which is MVP is basically doing your business, how is it that you would be entering that arrangement if not also anticipating that they can only complete the arrangement for DHL and do the work for DHL? They don't use these trucks. Therefore, the hiring is of the trucks.
Well, I think...
I mean, how else are they going to complete the service?
But I think my colleague answered that, and I would...
I want to hear from DHL.
Yeah. But I think it's one thing when you have the agreement to ensure a certain quality control and that its trademark and image is protected, and then it leaves up to MVP discretion on how to complete that task. So they were hired, MVPs hired to transport and to complete deliveries, and how MVP does that is up to MVP.
But you're not expecting them to do it without trucks.
I'm sorry?
DHL's not expecting them to do that without vehicles, correct?
But it's up to MVP to use whatever vehicles that they deem appropriate for that
Would
task.
this be a different case, counsel, if DHL insisted that MVP only use its trucks to transact DHL's business as opposed to being able to be a free agent, essentially?
I think it may, but I think in this case, that's exactly what happened, is that all the discretion was left up to MVP as to how to complete the task that it was hired to do.
So you're saying DHL would only be exercising control or exclusive control if it required MVP to just do its business?
I
would say no, that wouldn't be enough.
I'm not saying, I wouldn't say that would be enough, but I think, and going back to the point of permission, I think this is all moot based on the Fourth Department's finding of lack of permission. But to answer that question, I wouldn't concede that that would be enough.
Thank you, counsel.
Thank you.
Mr. Markarian?
Well, how does our decision in Dairy Lee play into all of this?
Dairy Lee is very helpful, Your Honor, because Dairy Lee has a two-step analysis, and the appellate division in this case jumped to step 2 without doing step 1. Step 1 in Dairy Lee, this court looked at the policy and to find out if there was coverage in the policy, thereby indicating that there could be coverage for the tanker in Dairy Lee, but when it looked at the policy, it found an exclusion. In our case, when you look at the policy, without the cost of hire schedule, but assuming the cost of hire schedule shows that these vehicles are insured as hires, that's step 1 of Dairy Lee. You stop right there. There's coverage under the policy. Dairy Lee only went to a control analysis.
But if we disagree with you on that, doesn't Dairy Lee make a distinction between control over various aspects of how the business is carried out and control over the vehicles themselves?
But Dairy Lee, it says that you need to hire a particular truck, but that logic...
Well, if we get to that second
Yes.
factor, where are we here?
What we have here is, instead of hiring a particular truck, you have hiring a complete fleet. That's what they're doing. So it's the same logic of Dairy Lee. If you're not, you can't have a separate contract for 7,717 vehicles. What they do is they hire fleets, and they have a separate cartage agreement for each fleet, which is what the underwriting expert explained. I would love to address permission and make 3 points on permission. It seems to be very important.
Please do.
Number 1, you have to construe the policy against the insurance company. Number 2, if the permission analysis were different for hired vehicles than it is for owned vehicles, there would have been no reason for the insurance company to put in symbol 9 that there's a limitation that the coverage went away if it was for a non-business use, because the definition of permission would have already wiped that out. It wouldn't have had to be in symbol 9. So you construe the insurance policy against the insurer. They have to have that meaning, otherwise they wouldn't have to put the limitation in symbol 9. And again, they wrote the policy. They wrote it to say hired, owned, permission in one sentence. I don't think it's a fair construction.
Isn't that your argument on this? We have this case Merzda, right, where Brown and Wood is kind of the lessee. There's an owner, PHH or whoever it is, they're the owner. Brown and Wood puts this thing in their contract saying you can only use this for business, and we say, okay, that's good enough here, but as an owner, you're implied to have given permission, even though the B&W sub that's leasing the car from you has put this provision in and can get off. You're kind of flipping that, right? And you're saying, well, the owner here, which is MVP, they can be liable, but the hired auto, you can give permission. It almost seems to be flipping Merzda on its head to me.
Respectfully, no, Your Honor, because they wrote the policy. They could have written it the way you're saying, just like symbol 9. They could have said there's no coverage if it's for a non-business use.
But you're imputing permission to the person hiring rather than the owner. And Merzda said, well, you can do that with the owner, and again, I think it was PHH or whoever the company was there, but not Brown and Wood. Brown and Wood, you went by what their policy was with respect to their employees. But now you want to impute permission to the one that's hired the vehicle.
Well, I think this is crucial, Your Honor, and this is what the appellate division did in this case, because I thought before you were talking about permission went away when it was for a non-business purpose. But I think your question now is that the permission can never be granted. So that means that there's a hired auto schedule that says these vehicles are covered, but then the permission language erases the coverage. That's an illogical result.
But if the person were using that vehicle to deliver a DHL package, you'd have coverage.
And that's what it says, and it does not take that coverage away when it's for a non-business use, which they did do in symbol 9 for employee
Doesn't the
vehicles.
permission part say that?
No, because they are writing the policy. When they want to take that away, they expressly do so in symbol 9 for employee vehicles. They don't do it for
I'm sorry,
hired
I
autos.
couldn't hear the first part of your
When
statement.
they want to take away the permission for non-business use for employee vehicles, they expressly do so in symbol 9. They don't do so for hired auto in symbol 8. They wrote the policy. It should be construed against them. They've equated permission for owned to permission to hired. And I'm sorry, I'm over, Your Honor. Could I have 30 seconds on the
You may,
cost of
sir.
hire? The cost of hired schedule is at page 1812 of the record. It says, this is their schedule in the record, in the policy, per schedule on file with company. We need to see that schedule. If you look at the Manchester case, you'll see how these schedules work. Judge Stein asked about, is there any reference to New York State? Well, there very well could be in that cost of hire schedule because it gives a state breakdown. So it's going to break down by state. So all of the DHL contractors in New York, let's say they're 5, and let's say DHL pays them $1 million. That'll be in the next column. And you'll see the underwriting evidence in this case, Your Honors. The underwriters are exchanging the information to complete this schedule. They're asking for the state breakdown. They want to know if the contractor insurance is primary. They're doing this for the cost of hire schedule that we don't have on a 3211 motion, and the motion should be denied, and that's our position.
Thank you, counsel.
Thank you, Your Honors.